All right. Good morning. I'm advised that there's a slight technical glitch on the side of the Road Accident Fund, but they are trying to log in. So they will give us the green light when they are good to go. But from our side, we're good to go. The ministers here, deputy ministers here, and the DG and the other officials. So I think we will be, we'll just wait for Raf to let us know. In the meantime, can those who need to present the presentation be given the sharing rights so that we will be able to jump right into it? So can we do it in that fashion, please, so that we avoid other technical glitches? So we'll be in the hands of Raf then, and then we'll be good to go. All right, I see.
Chairperson.
Hello.
Good morning, Chairperson. No, it's Utandi, the PLO from the Ministry of Transport. I was saying the CEO of RAF has connected. So we are good to go.
Good morning, Chair. I'm here.
Yeah, I did see him connect, and he is now a co-host. All right. I think we're good to go. I don't anticipate us having a long meeting. So that this is just to look shy and get keen. All right. Colleagues, let me take this opportunity and welcome you to our first meeting of this term. It's good to be back, and of course appreciate the fact that we did have a few meetings during the recess period, true to style to our commitment as this committee to push as much as possible. And so I'd like to thank you, colleagues, for being available during the recess as well, when we needed to actually meet. And of course, thank you very much once again for all your messages whilst I was indisposed. I would like to welcome the Minister of Transport, Ubaba Mbalula, and of course, we welcome the new Deputy Minister, Umamu Chikunga, who's not, of course, a foreigner to this department, having served as Deputy Minister before in this portfolio. So we welcome her as she has now returned to this portfolio, and then the DG and the CEO of RAF and the team. So what we'll do, colleagues, is I'm going to hand over to, because there are not many issues, as you know, but we need to close down properly on work that Parliament had done with RAF and tie it down properly. They have received a clean audit. There's just one or two areas here and there. and then get an update on how far things are and what interventions have been made, so that for now we can then, of course, close the books of RAF on our side and then just continue to assess. And I'm sure that the work will be in the capable hands of the portfolio committee. So it is to make sure that everything is up to date. There is a presentation which has been circulated. So let's then, Minister, I'm going to hand over to you remarks that you would like to make, introductory remarks, and then hand over to the Road Accident Fund to make their presentation. And of course, request that then there's a hand. But now that hand has got no name. Zoom user.
Good morning, sir. I was just trying to change my Zoom user to my name. It was a mistake. Thank you.
Oh, okay. We're very observant here. We want to make sure everybody who wants to say something is afforded that right. Okay, Babu Minister, let me hand over to you, and then you'll introduce from the ministry side and the department side who's there, and then we'll hand over to the Road Accident Fund once you have concluded with your introductory remarks. Colleagues, I hope that is in order. And we'll move in that fashion. Once again, good morning and welcome. Minister, over to you.
Good morning, Chairperson, Honorable Chairperson Mkhululeko Hlengwa, Deputy Minister Sindisiwe Chigunga, members of SCOPA. I'm with the Director General of the Department, the Chief of Staff, and my two advisors. And as well, we have the Chairperson of the Board of the Road Accident Fund, Ms. Tembelihle Sibi, and the Chief Executive Officer of the RAF, Mr. Collins Litswalo, and his team, which he will gladly introduce them when given a chance. The Road Accident Fund, Chairperson, has operated on a financially unstable model for a number of decades. In recent years, the fund has also experienced liquidity challenges as claims against the fund has outpaced the growth in the RAF levy. The current system is inequitable as the payment of damages, loss of earnings, and general damages per individual are assessed in relation to the person's earning capacity, and potential earning capabilities is disproportionate to those that are deemed to have or be able to reach that earning capacity. When we appointed the current board towards the end of the 2019-2020 financial year, we concluded the shareholder compact that outlined key priorities. This included reduction of legal costs, revisions to the operational model, implementation of an integrated claims assessment system, and strengthening of the supply chain management system. For the longest time, there's not been a nexus between the fuel levy and the number of accidents that occur on public roads. However, to exacerbate this challenge is the ever-increasing administrative costs of the RAF scheme. Of the revenue collected, approximately 17 billion, 40% of this goes to administrative costs, with only 26 billion, 60% received by claimants. Currently, the RAF biggest cost driver is the number of road accidents that occur on public roads daily. As at 31st
Recording
March,
in progress.
As at 31st March 2020, the RAF accumulated an annual deficit of 5.3 billion and also had claims to the value of 14 billion that had been finalized, but could not be paid due to the financial cash flow challenges. Claimants had to wait on average 1,475 days for their claims to be settled. The average value of a claim also increased by 21%. Claims against the fund have increased at an average annual rate of 8.4%, from 61.3 billion in 2017-18 to 78.2 billion 2020-2021, and are expected to increase to 102.9 billion by 2023-2024. As a result, the accumulated deficit is expected to increase to 518.7 billion in 2023-2024. The other biggest cost drivers for the RAF are legal fees that the entity has to settle, both in terms of its own legal costs and those of the claimants. Of the 43 billion fuel levy received, 10.6 billion goes towards legal costs. In the 26 billion rand paid, there is a further success fee to the plaintiff attorneys as part of the contingency fees agreement entered into between the claimants and their legal representatives. In some instances, operations within RAF are suspended due to the attorneys attaching some of the RAF assets. Provision of legal attention is also a problem due to lack of harmonization and standardization of medical attention rendered to road accident victims. In some cases, victims approach specialists for injuries that do not warrant those types of services. There is also a need to deal with money spent on providing for medical attention to victims of car crashes. We have identified the need to prescribe set and standardized medical tariffs that victims of accidents submit to the fund as a result of motor vehicle accidents. Inefficiencies in the claims administration process is attributed to disputes being declared by both the plaintiff and RAF attorneys. Where the legal costs are incurred, there is a little value added, as more than 90% of these claims are settled. However, the attorney's fees for the work done are expected to be paid by the fund. For the past 5 years, an average of less than 5% of RAF legal matters have ended up in front of a judge, while constituting more than 80% of the civil trial court rolls. The lack of early investigations and settlement of claims has also resulted in funds receiving an average of just over 4.353 summonses per month, of which some of them may be fraudulent claims. Bringing the RAF back to financial stability will require both a regulatory overhaul and operational improvement. Due to the liquidity challenges, the RAF has experienced attachment of its bank accounts and movable assets through the writs of execution. This has led to the RAF having half of its monthly levy income attached. The need for asset and liability matching when the RAF pays installments or periodically rather than in lump sums cannot be overemphasized. In addition to operational challenges, RAF operated with most of 2019-20 financial year with an interim board and an acting chief executive officer. Following the appointment of permanent board and CEO, the RAF have since embarked on a new 2025 strategic plan, which is a complete departure from the previous plan. One of the devastating effects of the litigation strategy was the constant rates of execution which RAF was subjected to. The current RAF board and management have since brought the rates of execution risk under control. This was achieved by changing the payment strategy. The result has been improved liquidity position for the fund, recovery of over 400 million in duplicate payments, and thus over 100 plaintiff firms were reported to the Legal Practice Council. During the period under review, RAF achieved a performance of 57% against its annual performance plan. Although this was a drop in performance compared with the previous year, this coincided with the change in strategic focus. The RAF obtained a clean audit outcome from the Auditor General for 2019-20 financial year. This is an improvement from 3 consecutive years of unqualified audit outcomes. The RAF has further strengthened internal control measures to prevent instances of fruitless, wasteful, and irregular expenditure. The chairperson of the board, Mr. Mbeli Tlemsivi, will lead the detailed RAF presentation together with the CEO. I thank you, Chair.
Thank you very much, Minister. We'll request that statement that you have made, if your office can send it through in the soft copy, just for the purposes of our records, in as much as we have it. So we'll request that as well. And thank you very much for that statement. So as colleagues, we said there was a clean audit, but there are issues that still prevail. And one of them has was flagged now at the tail end, the performance percentages. So we want to make sure that the audit outcomes, whilst clean and the financial controls are in place, performance goes toe to toe with that. So let me then hand over to the chairperson of the board, who will then indicate to us how they intend on structuring their presentation as a team. And then colleagues, you will come in after that to then pose the questions. Chairperson, over to you.
Thank you, Honorable Chairperson. The CEO will lead the presentation, but just before he takes over, I would like to indicate that we have with us the Deputy Chairperson of the board as well, Dr. Nomonde Mabuya, and the Chair of the Audit Committee, Mr. Hilmi Daniels, and 2 Audit Committee members, Ms. Lorraine Francois and Mr. Moses Nyama. The CEO will take us through the presentation, and thereafter we will entertain questions. Thank you.
All right, let's proceed in that fashion. And once again, request colleagues, if you are on the platform, I've been advised, please do turn on your camera, as we've seen myself, the minister and the chair do, for the purposes of the records, right? Let us continue as the chairperson has then given guidance. So for those who will be speaking, please turn on your camera, right? RAF, over to you.
Good morning, Chair. I don't know if you could see the presentation. Trying to share it.
You are sharing a screen, but not the document. You can see your Apple home screen. Right, the presentation is coming up. Okay. Okay, CEO, I think you can proceed.
Can you see, Chair?
Yeah, the presentation is up. We can see the
I hope you can see the presentation. Thank you very much. Ours is to give an indication on the 1990-20 and wasteful expenditure, as well as the deviations and expansions of the year 2020-2021 as an auditor. Start share with the intro, performance information, final expenditure, and then we'll conclude. Chair. This presentation is for 1920, as the minister has said. This has been a bit surpassed by events, financial year, which is not the year under audit, but the year that deviations in Q1, Q2, and Q3, as per the request of the committee. Then we look at the values, integrity, quality, and respect, together with excellence. And then we move to our business model. Just to show an indication, we receive money from the fuel levy, from the fuel sold, and we other investment revenue that comprise the revenue that we have.
CEO, just 1 second.
The operations and all things that happen at RAF, by security of guidance. Yes.
CEO?
Yes, Chair.
I'm not sure whether it's on my end, but your line is not assisting. I think we are battling a little bit to hear you properly. I don't know, but you can proceed, but just please bear in mind we are having a challenge hearing you.
Can you hear me now?
Yeah, you can proceed. I'll let you know if the line deteriorates.
Okay, thanks, Chair. Then the number of severity of the accidents, of course, drive the volume of the claims and, of course, the value thereof, which result in claims. And, of course, we have got what we call administrative costs and third-party costs of actually maintaining it. As the minister has said, this has been the split where administrative costs take about 40% of all the amount that we receive, and 60% only goes to the claimants. There is just the rough footprint. You would see our head office in Pretoria, and you'd see that the biggest chunk of what we have is hospital service centers. This model is seeking to change as we move forward to make sure that we provide better service and coverage to all our people. Now, the performance information, just by way of key statistics, the fuel levy has increased from 193 cents, which is 193 cents, to about 198 cents, which is about 5 cents increase, giving effect to about 2.59% increase in the fuel levy over this period. The total amount of paid claims increased by about 3.2%, from about 42.6 billion to about 44.6 billion. The average RAF and other cost per claimant increased from 37,000 to about 38,000. And you'd see that our call center responded to more than 433,000 calls compared to about 421. And the total number of permanent employees increased slightly by about 13 employees, from about 2,776 to 2,789. And of course, the biggest issue for us is the claim liability that grew by about 21.7% from 272 billion to about 331 billion. The average value per claim as well is a concern for us, and this has increased by 21.05%, which is from 114,000 to about 138,000 during the year under review. So the total revenue decreased as well from about 43 billion to about 41.24 billion, mainly as a consequence of diesel refunds that were there during the period. Now, the APP outcomes, we completed the percentage, as the minister has already mentioned. It's about 57%, which means we achieved 16 of the 28 targets that we set ourselves. The 12 were not met, mainly as a consequence of us halfway through changing the strategy as we arrived between me when I was seconded and the new board when it came in December 2019. If you look at the annual performance history, you would see that it was the lowest from about 77% in 1920. And you would see that the 2021 looks much better, but for these purposes, we are focusing on the 57% of the performance that we have in this current year. So much more of the challenges that RAF has had in this regard had to be addressed in this year. As we said, much more of what we wanted to do seems to change. The minister has already alluded to the fact that we had an improved audit outcome from an unqualified with findings to an unqualified with no findings, which means clean audit. On issues of claims performance, we see that the movement, 2,000 personal claims, while supplier claims represented about 1,201 of all new claims. But if you see the registrations there, it's about 303,000 claims, finalization of 258,000 claims, and we are left with about 359,000 that are still outstanding. And that's why you would see that even the amount of liability there has grown. And the outcomes from a claims analysis point of view, as it were, the claims that were older than 3 years increased from 70,000 to about 91,000, while the claims older than 3 years also decreased slightly, which also was showing an unsustainable trajectory that we had to deal with once we started the new model. The outcome on administrative costs, the challenge of administrative costs is still prevalent in the 1920 financial year. Of the 39.5 billion claims expenditure, 29 billion of that represented compensation to claimants, whilst the balance of 24.6 was administrative cost, that is legal other experts fees. But you must note, Chair, that out of the 75%, the lawyers, which is plaintiff lawyers, would still get a success fee of about 25% of those fees. So for us, that also remains something that needs to be dealt with. And on the financial information and statement of financial performance, very clearly our current assets were much lower than our liabilities. If you look at the current assets, you'd see that we've got 10.4 billion, receivables and non-exchange transactions, which are about 8.8 billion, which is the money that SARS still has got to pay over to us, which is money that has already been collected by fuel levy. Well, this money in the bank of about 10 or non-current assets to talk about, which is about 247 million. Then you'd see that we've got about 10.6 billion of in total assets against the total liability position, where current liabilities already is about 61 billion. Claims liability being the biggest one at 59 billion. And you'd see that other provisions are sitting at 1.5 billion, making a total of about 61 billion. And the biggest chunk of this liability, as we note, is the claims liability as well, long term, 271 billion. And you'd see that that results in a total liability position of about 332 billion. If you then subtract what you have on the liabilities, which is total assets, we are left with about 321 billion in the negative, meaning a net liability position of about 321 billion. That's a concern which we sought to address, and that's what the minister had indicated that we need to address as we move forward. The 90/20 outcome statement of financial performance really reporting the revenue and expenditure. You'd see that much more of our money comes from the net fuel levies, a little bit of investment revenue of about 62 million, and other income of about 25,000. But you'd see that the net fuel levy for the year reduced to about 41.1 billion from 43 billion, giving us a total revenue of about 41.2 billion. And you'd see that the expenditure, we had about 98 billion of that amount. And you'd see that the total expenditure resulted in about 100, and we have got a deficit for the year of about 59.6 billion. Chair. Just giving an indication of the claims liability for the outstanding claims recorded, you would see that it has increased from 173 billion in the previous year to 212 billion. This is the trajectory that we have said that is not sustainable, and you'd see that the liability for claims incurred but not yet reported, which is really what is called IBNR, is moved from 87 to 102 billion. And that resulted in about 330 billion of the claims liability that we have. Now, Chair, I'll move a bit to the deviations in this year, unaudited, which is the 2020-2021 as requested by the committee. You would see the name of the service provider there, the project description of what we were procuring, the nature of the decision that was taken, the reason for deviation, and the amount. Much more was spent on Microsoft Ireland as a sole source of provider for Microsoft products that we use within the RAF. And you'd see that we spend about 5.1 million together with about 73, so it's about 78 million that we expended towards that through a sole source procurement. And the advanced global systems also about 46,000 on the Informix database that we use, and is also a sole source. In the first quarter, we spent about 78 million on the sole source provision on Microsoft and that Informix database. Deviations in quarter two, you'd see that the name of the service provider there is provided, African SEP user group. That was just membership of about 48,000 rands. Mbuiseni group about 362, and about 63 from Eagle Stationers Computer Supplier CC. Those were issues of PPE in Durban as an emergency for purposes of, this is in line with the response that the government had to do on, and RAF as well, on issues of COVID. And we then spent 474,000 in that quarter. Expansions in quarter two, leases last year because of the lockdown, to actually go and assess leases and be able to make sure that we expand. But it has always been a difficulty that we've also discussed with the National Treasury about small towns in particular, and leases, even where we look for accommodation, there's not a lot of people that are able to provide accommodation that meets with the requirement. And even when we go out to market, usually we don't get the right responses. So sometimes we are forced to extend or expand. So the expansions were on the Cape Town lease, the Durban office lease, Mafikeng lease, Nelspruit and Polokwane, and we have spent about 29 million. As you see, most of those things are expansions to allow for a competitive bidding process to ensue. Deviations in Q3, really quite small. South African Postal Services for a private bank, and of course, Suspin Commercial Solutions for the DOSEX secure and confidential closed group services that they provide to us. Both of them are sole source. On the irregular fruitless and wasteful expenditure for 19 expenditure, you'd see a balance of about 453,000 of that. You'd see that we had fruitless and wasteful expenditure recurring, which is relating to the current year of about 15 million. And we have finalized of that about 15,793, and of course transfer to receivable recovery is about 8,000 of that. And you'd see that when we reconcile that, the opening balance was sitting at 12, and we recovered about 10 of that amount, and we are sitting at about 10, which is a net reduction of about 2,000 rands. But much more of what is important to us is to make sure that there is no repeats of this fruitless and wasteful expenditure. May I say, Chair, we are forced by the labor laws of the country to advance what is called progressive discipline. In this respect, Chair, the majority of the reported incidents, 53% thereof, related to hotel and travel-related booking cancellations. And in most instances, we ask people to pay back these monies, and the recovery process we institute, we were needed, employee are cancelled, and then 3 were given verbal warnings. And then 11% of incidents related to SARS penalty interest of the late payment of July 2019. And this was just undertakings, and there was error from one of the employees, and this was the person was cancelled and then received training so that this thing does not reoccur. 25% of the reported incidents are claims related. In this case, Chair, much more of what we found was that people would just simply not do what they are required to do, which is pay in time. Disciplinary action was taken, and then 17 received counseling, 18 verbal warnings, and 33 written warnings. 6% of this reported incident related to interest on the overdrawn bank account. And this, we just made sure that the reconciliation of that bank account is done properly so that we don't neglect. In this case, an ABSA fleet card debit order was neglected that led to an overdraft in the account. And then 6% of reported incident relates to amount paid by the RAF to plaintiff in respect of judgment made against for wrongful arrest and party with no debt in the amount incurred, wasteful expenditure, no responsible official could be identified internally, and therefore we couldn't take any action in this regard. Now, outcomes of irregular expenditure, as you see, the opening balance of 338, then the regular expenditure of the prior year reported at 3.7 million, and we didn't have any regular expenditure in the current year, and the amount that were condoned were about 160,000, and we remained with irregular expenditure pending condonation of about 341 million. You'd see that there was also 3 employees dismissed and 1 employee cancelled on non-compliance of the 3.7 million in the previous financial year that had to be reported in this year under review. That's by a form of explanation of those matters, GSA identified Med Scheme, Ernst & Young awarded a contract in 2014 to finalize claims under a project called Cienza. This investigation is still continuing. We've not finalized that, to make sure that people that must take accountability for what they did. Much more, Chair, I must say most of these colleagues have since left the road accident fund, but it's something that we're pursuing to make sure that we complete this. An offer for settlement was made by a claimant. It's a claimant accepted without being authorized in terms of the delegation of powers. A request for condonation was submitted to National Treasury. We have given one a written warning in relation to this transaction. As we said, the Standard Bank fleet used by contract had expired. Investigation concluded that it was not irregular and was subsequently removed as irregular expenditure in this year. So it will show in the new year when we report on irregular expenditure under audit. A consultant, Deloitte, was appointed via process without following the required legislation. The responsible employee has since resigned from the road accident fund. The RAF procured catering logistics. The employee received counseling, and the item has been condoned to 1920 annual financial statements. And we had also service providers that were regularly awarded to what we call home modifications, where 3 employees were dismissed. This was in the Durban region. Thanks, Chair. All in conclusion, Chair, this is prior our new model. You would see that the trajectory was downwards from what we see, increase in expenditure. We saw increase in the claims liability. And for us, that is what the minister and cabinet had requested us to turn the RAF away from, be able to drive a new model, driven at the basis of trying to reduce the time it takes for someone to wait for payments, which is 1,475 days. We want to reduce this to 120 days, and that we are going to do by way of making sure that we assess and settle claims within 120 days and we make payments within a short space of time. But that we are going to do without actually going through a litigation model that this 1920 financial year was based on, consequently spending more than 10.6 billion of the 17 billion that we spent on legal fees. And for us, that is not something that is sustainable, and we're working towards that. Additional to that, Chair, is an issue about attachments of our bank accounts and attachments of our assets that we have done through approaching the court in terms of Rule 45A. And we had that in this year in April, where the court allowed us to really stratify our debt book and make sure that the payments are at least less than 180 days, as it were. So it's something that we're working towards in line with our strategy for 2020-2025. Thank you very much, Chair. We'll take the questions.
All right. Siyabonga CEO for that presentation. Right, colleagues, I will hand over to you if there are any questions, and then you will let me check the group. All right, Honorable Van Minen, over to you.
Thank you very much. I do actually have several questions. If I can run through them, please.
I think let's do this because I think we are good for time. You can pose a question and get a response so that they don't get lost. Yeah.
Okay, great. Thanks. My first question is the regulatory overhaul that was discussed. I think we all know by now that the model used by the REF is not optimal at all. It does seem to have enormous structural problems. And I think certainly we do need to see some kind of regulatory overhaul. There hasn't been a significant one, not really, for quite a while. So I just want to find out, firstly, what kind of regulatory overhaul is proposed and what the time periods would be with that. Thanks. Chair, do you want to get a response to that, or should I continue?
No. I think, like I was indicating, Honorable Van Minen, we'll request that you pose your question like a hearing style. So RAF, once a question has been posed, I won't come in to just save time, and then you just give a response to it. So in response to that question?
Yes, thank you very much, Chair. Regulatory overhaul, Chair, would involve a couple of things. Firstly, is to ensure that we start paying our compensation in installments or progressively rather than lump sums. The rationale for that, Chair, is that most of the RAF claimants would need care throughout their life, some of them for the next 20 years, and once they were given the money, we have seen that much more of that money has been spent within a year or two of them receiving that money. But also from our side, there is no what we call asset and liability profile matching. So we receive our money monthly, but we have been paying this money in lump sums, which then create this liquidity squeeze that we have. That's the first thing. Secondly is that we are moving towards a process where we are going to make sure that we settle matters within 120 days, but we want to make sure that we have got enough information. What we have found out is that much more of the information that we receive is not enough for us to make an offer within 120 days, which leads to a litigation process because we then get summons and have got to go to court. That we are going to remove. The other issues on the medical side, RAF is paying about 5 times what medical aids are paying for the same kind of treatments, simply because RAF for a very long time did not have what we call RAF medical tariffs. There was the 2013 Concord ruling that doctors can charge what they wanted to charge unless RAF brings its own medical tariffs, and that's what we are working towards as well. We are also introducing medical protocols as part of that whole process. So our end-to-end, from the point of view and assessment, must help us to do those things as we move forward. So those are some of the things that we're introducing into the space. And as well, I think our RAF forms also need to change to make sure that, for instance, a RAF 3 form, which is supposed to be submitted by a driver or the owner of a car within 14 days, has not been effectively enforced. So that's what we need to enforce to make sure that we know who's going to come and make a claim, and then we can make necessary provisions for that. That is just on the surface, much more of what we're going to work towards. But the biggest issue is going to be making sure that we have what we call defined benefits for this scheme going forward, so that people know exactly how much they are going to get, and that it is much more equitable, because at this point, people who earn more will pay the same fuel levy but get more from the road accident fund than if you were poor and you did not have a job. The likelihood of you receiving more money and cover from the road accident fund is less. So those benefits need to be adjusted to be much more equitable. Thanks, Chair.
Through you, Chair, if I can continue with that. In terms of the last point, when it comes to definable benefits, are you proposing that you would then, in fact, be doing away with loss of future income? Because those tariffs would obviously be, well, what is currently being paid out is obviously based on loss of income. And people who have a higher income are potentially going to be financially losing a greater amount. Can you just clarify on that for me, please?
Chair, not necessarily that they will be losing. Yes, of course, that's what we are going to do. What we are going to do is cap the loss that people would have. It's always important to note that even if you went to any person that would provide cover, for a higher cover, you pay a higher premium. So that's not what is happening in this case. So you would get a person who is a domestic worker, same injury, same everything, with a person that is working for road accident fund like myself. I would get more, but I would have paid the same fuel levy in terms of the amount of money that I would have put down. I mean, for that as a cover. So for us, for it to be equitable, we must get to a point where everyone gets to a certain amount, a maximum amount, and then other people can afford their own cover. Because in our view, this is a social security scheme. It's not necessarily a scheme for other things. So it's important that people that can afford can provide for their own cover, in our view. So defined benefit also helps because we wouldn't be sitting in a position where we wouldn't know how much we pay out once that, and the provision becomes quite simple. At this point, there is a lot of things that get involved in that process, and therefore it does not make it clear to everybody. Thanks, Chair.
Okay, I think I might translate that into a written question, because I think that there's a lot to be unpacked. One can't necessarily just say that because everybody pays the same fuel levy, therefore there is necessarily parity in terms of how much people are paying. But I want to move on to the issue of attorney costs. So how does the payment of contingency fees impact on the deficit of the RAF? Because I mean, contingency fees are negotiated between the client and the attorney. Or are you intimating that the claims that are put through to the RAF are higher because of the existence of the contingency fees?
All we are saying, Chair, is that the road accident fund is for the victim. It's meant to take care of the victim. Administrative costs are actually assisting you to be able to get that. And our approach is very simple, is that where contingency fees, I mean, if there was no contingency fee or it was lower, you would get a situation where this claimant would get more as a consequence of that. So that's why we want to reduce the legal fees, which includes those contingency fees, because most of them are based on legal fees. So you take whichever is higher of the calculation that is done there as a percentage. So for us, it's important that much more of the money goes to the claimant, and that's how we want to be interested in that, because there is a claim that people take only up to 25%. The evidence we have suggests otherwise. So that's why we are saying it does not naturally impact on the amount of money that we pay on the outside, which would be monies that is paid to the claimant as a success fee, but it does impact on the litigation cost that we have. And for us, that affects how we operate as the RAF. As we say, much more of all the admin schemes that we get is a medical aid or any other that manages funds. And at the top, you would get people getting between 10 and 12.5% in admin fees. Our admin fees are sitting inefficiently at about 40%. And much more of that comes from litigation fees. As we say, out of the 17 billion, 10.6 billion goes to legal fees. And that includes those fees that are for the plaintiff. And for us, that is a concern, and we need to make sure that we reduce that amount.
I'm trying to understand how you're affected by the contingency fees, because a contingency fee is negotiated between the client and the attorney and comes from the lump sum that is paid to the claimant in this particular case. So I don't see how you would have a jurisdiction to determine what happens between the attorney and the client that they have. I mean, that's regulated by the relevant law societies. That's what I'm trying to understand.
I agree with you that this is by the relevant law societies. What I'm saying is that our interest is that of the claimant. If we are a fund, we're interested in what the claimant is paying towards claiming from us. So if definitely the contingency fee is higher, it might not affect us from the bottom line point of view. But if we sit here, morally, it is our obligation to make sure that these fees are lower so that the claimant gets the highest amount towards their claim. So if, for instance, you had a situation where someone is approaching RAF directly and does not have to go to pay contingency fee, and on the balance, this person must get more because it doesn't have to pay anyone a success fee. So it must not be difficult for someone to claim from RAF, which is why we are saying a regulatory overhaul is very important in terms of what we should be doing going forward. It's easy to leave it in the hands of the claimants because we suppose that all claimants understand their rights. And in majority of cases, we find that most of them are negotiating from a very poor background, meaning that they don't even understand this thing goes up to 25%. We have seen those things happen, and much more of that we have requested to the Legal Practice Council because people also take more than that. But what we are saying is 25% as a success fee for this model, where much is not really being done by the lawyer. It's not right in our view. It's not morally just in our view. Thanks.
Okay, so how much has been saved for the RAF by the non-renewal of panel attorneys vis-a-vis how much the RAF has spent on litigation where the courts have found against them?
If you take a split, we were spending about 3.8 billion on our panel attorney internally. In any event where it is not as if when we have got a defendant attorney and we lose a case, we don't pay those legal fees. So we pay those legal fees anyway. So we'll have the legal fees that we pay. It's about 3.8 billion, and there is a split on the plaintiff attorney side. We pay about more than 6.8 billion, so if you take those amounts, it's about 10.6 billion. So what we are saying is, in our new model, what we seek to do, we want to make sure that we don't have to go to court. What we have found out is that we pay that 10.6 billion. We, however, more than 99% of the time, settle these matters on the doorstep of the court. So it means we start a litigation process. People exchange pleadings only for them to settle at the doorstep of the court. And we then spend 10.6 billion for 99% of the time settling. In our view, that is fruitless and wasteful, because we could have easily at the beginning, if we have got all information, given a fair offer, which would have been accepted at that time within 120 days, and someone would not, consequently, you would save much more of that amount. So probably, I mean, we think that over the period, we have set ourselves a target of saving 75% of all those costs of 10.6 billion. So that must save us about 7.5 billion rands. That can actually go to the claimant. That's our approach to this problem.
Okay, and then also, I think it was about 2 months ago, the minister proclaimed that there was a surplus of about 3.2 billion. How does this now square with the fact that we're now being told that there's a growing deficit?
These things must be understood in a context. I think we are talking about 1920, and now we are threading over to what is unaudited, which is 2021. I would not want to go much into that, but the issue is for us from a point of view of the surplus, it must be understood that as you reduce costs, you are always going to get the money going to the bottom line. So when you take out the revenue that you have and you reduce the legal costs, that amount will go into a surplus. We must also understand that a surplus in terms of RAF is a snapshot. So at that end of the year, we say how much have we received, how much have we paid out, and that is a surplus as a net off. Our issue is that ultimately what you need to see there is what we call a zero net off. So you shouldn't have a deficit, but you should not have a surplus per se. So because that money must actually be paid out to the claimant. So that squares off from a deficit point of view, because the actuarial deficit that we have been calculating works on how many outstanding claims are there, which is on the balance sheet side. So it must be understood in that respect.
Okay, I think that's all my questions for now, Chair. Back to you. Thank you.
All right, thank you very much, Honourable Van Minen. Honourable Mente, over to you.
Thank you very much, Honourable Chair. The question that was asked by Benedict covered me. However, the answer was inadequate for me. I'm going to try and simplify it in this manner. Firstly, the RAF component came not to account because of irregularities in finance and everything, but mostly because there's an outcry in terms of payments. There's an outcry in terms of what the CEO is indicating of more percentage that's being charged by unscrupulous lawyers to people who unknowingly sign papers and get lesser amount than that which is claimed from RAF. Now, in the regulation, CEO, I want you to take us, because here we are trying to curb a situation of people being robbed of what you calculate there as a loss of future income to the victims, as well as taking care of their welfare. As you correctly put it, it's for you on your side is to take care of the people's welfare in case of them being incapacitated due to accidents. Now, your regulations, what is it that they are going to cover to ensure that victims of accidents in this country are safeguarded? The net that you provide does not go to unscrupulous lawyers, and also take us through the role of Competition Commission in terms of covering for the lawyers' businesses and the law society that then determines those percentages which must go to lawyers and not go to victims. And what is it you yourselves as government, you are seeking as a remedy to ensure that there is much more awareness to the people in order for them to be aware of the fact that they don't really need lawyers to apply for this welfare, and they can get their 100% lump sum guided by your office without having those unscrupulous lawyers and unscrupulous doctors, by the way. So I want you to take us through that regulation. What is it that you want to achieve in the regulation? How are you safeguarding the victims and the provision thereof of this particular welfare? How are you going to break it down, and how are you going to make sure that the victims get it? Because the outcry is just that either the lawyers take it, you pay it to unscrupulous lawyers, knowingly that the lawyers stand in for the people, but there is no background check of whether the victim is going to get the same amount of money, or these lawyers will not even pay it. Thank you very much.
Right. We will use a similar approach.
Yes. Thanks, Chair. We have been in a big battle, Chair, with the legal fraternity. One is that, in their view, they have a relationship which is attorney-client relationship, principal-agent per se, and in their view must not even discuss with the claimants. So the difficulty is when you are a represented claimant and you phone RAF, we even fight whether we should give them information about what they got. And our view is that we are an entity of state. And therefore, there is a principle of Ubuntu as described in the Batupili principle. From that, we have asked that any person who goes through a lawyer, they must expose that contingency-free agreement to us. We are now requesting that this contingency-free agreement come to us. And the argument has always been, but why are you asking for this? And we say, but you don't have anything to hide. Because Section 19, I think it's C, of the RAF Act expects you that if you want to come through the RAF, you either come on your own or you use a lawyer, you use a government employee. We don't know why it was stated like that, because a lot of other people could actually help you do this. In our view, doctors are better people to know whether someone is injured or not, and not necessarily lawyers, and we don't know why they are not in that list. So what our issue is that we need to understand, you must remember we administrate this fund for the benefit of the claimant and not otherwise, or not for the agents that purport to represent claimants and their interests at heart. So you know, Chair, that a lawyer works on the longer time they are selling time. So the longer time it takes for us to settle a claim, the more the lawyer benefits. The lawyer benefits from not settling a claim than settling a claim within a short space of time. Because if you don't settle that in time, and therefore the legal fees are higher, it means this success or contingency fee becomes higher because it's calculated on the basis of that. So we are seeking to make sure that our people understand, and our issue is to make it easier and simple. So the issue of the 120 days, Chair, is that once you lodge a claim from RAF and you claim, but the RAF does not give you an offer within 120 days, if you need to issue summons. Now, here's the problem. If you were coming to RAF directly, you come and you lodge a claim, and RAF does not give you any offer. As a layman walking the streets, it's very difficult to then issue a summon. A summon is an intricate thing that is usually issued by lawyers. You need representation and all those things. That's why our aim is to make sure that it's so simple. You give us all the information that we require. We are forced that in 120 days, we give you, within 120 days, we give you an offer. It should not be you are taking us to court because we never even gave you an offer. It must be because you are not happy with the offer we gave you. And therefore, that's why we are also bringing issues around mediation before we can actually go to court. So we are trying to reduce the intricacies and the complexities of the RAF by doing that. And as we say, if we go to defined benefits, it's going to be easier to know upfront how much you are going to get. So it's not going to be a matter of big differences, as it were. So we had a situation where we had two sets of lawyers. We had our own lawyers who were interested in legal fees. We have the plaintiff lawyers, which are claimants lawyers, also interested in legal fees. All of them, they are litigating, but we were saying this is pseudo litigation because just as they go to the doorstep of the court, for some reason, they managed to meet and settle these matters. And the question was, why didn't they settle these matters at the beginning before we could even go through a prolonged process of exchanging pleadings and doing pre-trials and all those things, only to settle towards the end? So it is something that we are working towards, and that's why there would be this pushback from the legal fraternity. Because if you even go and look in 2002, when the Sexual Commission report was released, you would see that the legal fraternity benefits a lot from this RAF system, and therefore that's why they want to intend to keep it the way it has been. And this is why our pushback is, this is for the claimant. This is not really for the legal fraternity. Yes, they can come in and assist, but if the costs become too high, as it is now, it now defeats the purpose, because out of each and every rand that we collect on fuel levy, at least 90% must actually go to the victim, not the other way around. Because at this stage, if you do the calculations, it's 50-50 between them, the claimant, and ourselves, whether it's through this as administrative costs. And for us, and when you talk about unscrupulous, it's those issues that we deal with. We reported 102 law firms to the Law Society for duplicates that they were receiving. Because at RAF at that time, it looks like because of these attachments, a lot of reconciliations could not be done. So they would receive money from the sheriff and they'll still claim this money from RAF, whereas they know they've received it. So those are the things that we are dealing with as we move. And these are the changes that we are going to require from the amendment acts that have been sent to the department and the change in regulations that we have put in, which says you must give us the minimum requirements for us to be able to make an offer within 120 days. Thanks, Chair. I hope I've been able to answer.
Thank you, Chair. At least the answer is, as much as is not 100%, it's I can hear what you're trying to achieve. Then the next question becomes, you are indicating already that there are amendments that have been proposed. I want to check, Chair, through you, if the Minister can come in to indicate to us the amendments of those legislation. Are they already proposed by him to the committee, and how far are they? Because the sooner we regulate this whole process, the better. We cannot sit with a position that allows the legal fraternity to take 50% of a welfare of a poor victim. Simply because, and I can assure everyone here that most cases, 99% of the cases is people who have no knowledge of the process itself, who have no knowledge of within this contingency fees, how much by law is due to the lawyers, and they end up receiving not even 50%. In most cases, they receive far less, 20%, and it's very unfair to victims. Victims do not know. Therefore, us as government, we ought to protect the society from this unscrupulous behavior of the legal fraternity that takes money from poor people. However, the department has to fast track this whole process. Now, can we get an indication from the minister if they had already proposed those amendments to the legislation, and how far are they, so that we see if we have to, as a committee, when we are making a report, and also having to communicate with the office of the Honorable Frolik, in order to ensure that this particular amendment find expression within the processes of Parliament, and it is actually fast-tracked. Thank you, Chair.
Okay, Minister, there was a request that you say something, but we will give you an opportunity at the end, as we usually do, to conclude. So please take note of that. All right, Honorable Liz.
Good morning, Mr. Chairman, and good morning to our colleagues on the committee. Mr. Chairman, I've listened with some frustration, really. The RAF is bankrupt. It has liabilities that exceed its assets by over 300 million rand, and so the CEO discussion about legal fees and so on, whether it's valid or not, I'm not going to comment on, but it's not the focus that there should be here. The focus should be eliminating the need for legal fees by paying up and running an efficient organization. It's not happening. It's not happening even as we speak, given the figures that the deficit for the past year that we're looking at. That's the problem. The administration costs are far too high. I don't know what the CEO himself is paid, but I mean, clearly that's where the focus must be. And so the question is, when will the deficit be eliminated? How long will it take? And when will they start processing claims within the 120-day limit? That will eliminate the need for legal action. The legal action is a direct result of the inefficient and poor performance of the fund itself. So CEO, your administration is the cause of the problem. Please, can you tell the committee when you plan to eliminate the backlog and achieve a 120-day or less dealing with claims? And you should, as CEO, have a timeline for that. Don't come and tell us, oh, I'm trying to do it, or we plan to do it. When, Mr. Chairman, please?
CEO?
Yeah, Chair. Let me put it like this. Here we are dealing with the post-mortem. Because in 1920, we were asked to take over from the road accident fund and try to arrest this decline. The RAF has been bankrupt since 1981, Chair. Now, we come and we find the situation. And the question is, what did you do about it? Let me allay the fears of the honorable member by saying the cost of employees in RAF is 1.8 billion. Nowhere close to anything like 10 billion we pay to lawyers. What is this 120 days and what have we done about it? If you look at the 2020-2025 strategy that we have, you would see, Chair, that we intend to start finalizing claims within 120 days. We have done away with litigation model. We have done with what we call administrative model that deals with the assessment and settling of claims within 120 days. We also have brought in what we call the minimum information requirements, Chair. What we have been receiving at the Road Accident Fund has been claims that are incomplete. Incomplete in a sense that even if we wanted to make an offer, there's not enough information to make an offer. We have now published what we call minimum information requirements for comments, and I think it closed some time back. We are looking at those comments. The aim is to make sure that any claim that we receive, and we call it a claim, is actually a claim in terms of Section 24 of the Road Accident Fund Act. I will tell you, Chair, that 80%, or even 90%, the 80% of the claims that we receive at the Road Accident Fund do not have enough information for us to make an offer. Meaning 80% are meant to be litigated upon simply because the represented claims in the main that attorneys just simply put in what we call rough form 1 with no supporting documents. And those supporting documents are necessary for us to make a determination of whether we are liable, and in case where we are liable, for how much are we liable, so that we can make a competent offer that can be acceptable. And that's what we are doing. We are working towards that. Secondly, we found a situation where RAF, because of the liquidity challenges it faced, bank accounts were being attached. Our bank account was attached. The attachment, Chair, when we started, were at 1.8 billion rands a month, meaning half of what RAF collected in the fuel levy was going into REITs already. When we don't pay, people come and take the computers, they come and attach the bank account. We can't even pay salaries because the bank account is attached. That we have dealt with. We have gone to court, we have asked for a reprieve. We have also stratified our liability book so that people are paid equally. Lawyers, big law firms used to go get what is called a fixed allocation. Big law firms that we thought do other things are actually in the RAF space. And what they do, they got something like 100 million, some 65 million a month to apply to the debt that the RAF potentially owes them. That is also perpetuated on the other side because they keep on issuing summons. We had to stop that. And that's what we have done in this regard. And I'm saying, since 1981, there's been a lot of other things that have happened. Of course, we have predecessors. We take the good and the bad, but we must be given a chance to implement this strategy. I would ask the honorable member to look at our new strategy and what the targets are there. Very big targets in terms of what we want to do. And we think, given the first year that we had and the even unaudited statements that we have submitted, we think we are moving in the right trajectory, Chair. Some of the issues, including the way we account, because we are a social benefit fund, we are not an insurance scheme. And the way we have been accounting like an insurer. So there are a lot of other things that we are resolving in the process, as we said. The amendments that we have asked for, there will be amendments to regulations we are asking for, there are amendments to the very same forms that we found there that we had to change so that it gives us more information and more capacity to be able to make offers. And in that regard, we are going to reduce the number of claims that we receive. I must emphasize, Chair, that for as long as there are road crashes in South Africa, as we have them, we are going to have a lot of claims that are going to come our way. Ours is then to deal with it to make sure that our system is efficient and it's simple enough for anyone to claim from. And that's what we are trying to do. And I think that the first year of the 5-year strategy that we have set ourselves has been a good year. So we want to continue on this trajectory. I don't think 1920 does justice to what we are doing, because it was before. The year ended 3 months before we could start with the new model. And our new model started on the 1st of April, 2020. And I think when we come back to Scopa, you would see the differences that we have actually implemented. Thanks, Chair.
Yeah, Mr. Chairman, the obfuscation here is incredible. I mean, I asked specifically for when this would happen, and I don't get an answer. I get told to look it up myself. That's not acceptable, Mr. Chairman. The obfuscation is enormous. Where on earth do you get, Mr. CEO, the figure of 80% of claims are incomplete? Can you provide a report to this committee by the end of this week of the showing that 80% are incomplete? I would like, Mr. Chairman, for that to be recorded. Then the question then remains, of the 20%, are they being dealt with within the 120 days now? If not, why not? And when will they be dealt with within 120 days? Please don't obfuscate. Please answer the question.
Chair, there's simply no obfuscation. I think the honorable member is being unfair. One is, I have answered, Chair. I've said to you what a 5-year strategy. The problems of RAF are a long time. They are not going to be resolved overnight. That's a fact. Now, he's asking, where do we get that? We have got a work that we did when we brought in the minimum requirements that we did from the 1st of April 2021, where we said these are the minimum requirements for you to be able to get a claim. And you would see there's a lot of, we can give that report, Chair. I don't think that by Friday it will be fair, but by next week we should be able to give you that all that information. But the issue is, when we ask for minimum information that we require to be able to settle this thing, we were taken to court. Those things are there because it's very simple to say, well, RAF has not done anything. We have done a lot of work in this regard. So there's no obfuscation about what we are doing there. We can't say it is continuing to be as it were. As I say now, Chair, we had attachments of 1.8 billion. I don't think that our attachments are even 1 million as we speak now. We had a situation where our debt book was sitting between 2,000 days and 30 days, if it were. We are now sitting below 180 days because we have stratified our liability book. The difficulty with this is that we are now being told that it must take a short space of time, where we have been given 5 years by this strategy and with targets that are in there. As we said, the reduction of legal costs over the period of 5 years would be 75% of this legal cost. So we reduce them as we know we've got targets each and every year. I'm saying this because, Chair, I could sit here and say, well, I'll give you our strategy. That we can also submit to the committee if there is a need. We can submit to the committee the achievements that we have achieved over the past 12 months, which is the next year, which is the 2021. We have our achievements there. We have recorded those achievements. So it can't be correct to say that it is business as usual at the RAF. It can't be correct to say the RAF continues on the same trajectory. As I say, it is going to be important to look at what we have done from the accounting point of view, to look at the issues of the liability and how we seek to reduce that liability. I have talked about the new tariffs, medical tariffs that we are bringing in stream, because now we are paying 5 times what the other medical aids are paying, and we are reducing that to be aligned to the medical aid fraternity or the medical funders fraternity. So I'm saying Rome was never built overnight. We are not saying that all is hunky-dory. We're not really saying that. We are saying we are working towards a plan. A plan is recorded. It was submitted in Parliament, and that's what we are focusing on. And the minister holds us to account on those matters. And we do report both to the minister and to cabinet and the portfolio committee on the progress that we're making in that regard. And it will be important that the committee also refers to the portfolio committee on transport to see what we have done in this regard. So I don't think that we won't say we are there yet, but I think that the offshoots of our new strategy are there and they're starting to show. So if there is a need to show that we are certainly sure that 80% of all claims we receive do not have all the requirements, that we can bring on board as well. There is no issue about it because that's the truth. We are not saying anything that is not true here. Thanks, Chair.
Thank you, Mr. Chairman. I'm afraid the obfuscation just goes on. My question was, in the 20%, are they being dealt, who presumably they've got all the requirements, are they being dealt with within the 120 days? And if not, why not? So that essentially is the question. And the other question is, when will you clear the backlog of over 300 million? Tell us, if you say there's a 5-year plan, tell us by the end of financial year 2024, we will clear it. But just tell us, give us that. And then give me details, please, of why the courts ruled against your minimum requirements.
Mazamba.
I mean, the court, presumably you went there and you argued your case, but the courts decided that your case wasn't good enough. What were the court's reasons? Can you give us more detail about this court ruling that you claim is hindering you? Or you appear to claim. I don't want to put words in your mouth like you appear to be doing for me.
Okay. I wanted to suggest that we don't have questions lost. So can we pointedly answer the first 2 questions that have been recurring and then go on to the court's question so that we move seriatim with the issues?
Chair, one question is whether the 20% have been dealt with within 120 days. Yes, they are. And when are they being dealt with in 120 days? As we speak, Chair. That's what is happening in the Road Accident Fund. Once we receive a matter and we register it and it has got all the requirements, we do make sure that it goes to determination. And once it's determined, then we make the offer. So it's happening as we speak. So there is an issue about what did the court say. The court simply, we agreed that we issued a requirement in terms of Section 41A of the Road Accident Fund that says we can set the terms and conditions under which the payment of compensation is administered. And that's what the board did. It issued a minimum requirement, and we were told that this must be gazetted. When they were gazetted, we were told that this must be brought in for comments. And that's exactly what we did. So we agreed in court that we are going to require this, we are going to take it back. So the court did not rule against us. We agreed when people made an issue about it, and the lawyers made an issue about it. We went and we said, that's fine, let's open it up for comments. And that's what we did in this regard. So there is no obfuscation there, Chair, very clearly. So I hope I've answered the first 2. I'll answer the questions as they come, Chair. Seriatim.
Mr. Chairman, the backlog of over 300 million?
Yeah, that's why I was going with the questions. All right, let's get a response to that.
Yeah, the backlog of we don't have a backlog, Chair, of about 300. We have got a liability of 300 billion. Now, this liability is divided into a couple of things, which is the OCR, which is what has been received, which are claims that we have received already that we have not paid out or we have not settled as yet. And then there is what is called IBNR, which is about, I think that is about 200 and some odd, and then we have got about 120 billion, which is incurred but not yet reported, meaning an accident has happened. We are actually waiting for the claim to come through. So that makes the full liability, as we see, it is an actuarial liability, it's not a real liability per se. So that is the 300 billion. So what we have done in this regard is that we have looked at the accounting treatment that we have, and we are working towards resolving this thing through accounting properly for that liability. And this will come in the 2021 financial statements, as you'd see it. Now, there is an issue about 300,000 claims. I think it's 350,000 claims that are there. So we have got a process where we deal with issues around the backlog. So these are the ones that are at different levels in the claims. And you know that there are supplier claims that we must deal with. So supplier claims takes a big chunk of that away. And we are about, let's say we have got about 120,000 that are actually claimants claims. So this is not the hospital, this is not like, let's just say a doctor and all those. These are just claimants that we're working towards. We've got a team that is now making an offer. We've got a settlement hub that is sitting, looking at those claims and then looking at them from the oldest claims first and trying to clean them out. That process we have set ourselves is going to take us another 2 years to go through while we are busy resolving the issue of making sure that the other ones are done within 120 days. I hope that answers the question.
Thank you, Mr. Chairman. Anyway, the question of settling these claims within 2 years, where are the funds going to come from?
Chair, the settlement of claims, we do not deal with this thing from a point of view of funds. We start by settling claims and then we then agree how we pay these claims. For instance, we have got claims that have been settled. We are sitting at 17 billion at some point. We are sitting at 14 billion in this financial year. So we seek to make sure that we pay as we get the money. We then pay. We agree with these claimants on how we are going to settle those debts. So the aim is just to make sure that those claims are finalized. Because if the claim is not finalized, even if we have the money, we won't be able to pay that amount. As we say, as we go forward, the aim is to make sure that we balance what we call an asset profile and our liabilities profile. Our liabilities profile is payment in lump sum, whereas our asset profile, where we get our money, we get it on a regular basis. We are going to do that, and we have agreed that there may be a need, given the amount of money that we may want to pay out to go into the market and raise this money, so that as the money comes to us in monthly basis, at least the people whose claims have been settled would have been paid. So that's part of the process of the new strategy, as we have it, that we would go into the market and raise some debt to be able to actually consolidate the debt that RAF has, rather than owing a lot of other claimants. At least you then owe the financial institutions and investors that amount. So that's another process that we are dealing with as well.
Mr. Chairman, thank you. I'm just a simple bookkeeper, but to me, when you talk about finalizing a claim, that includes payment of the settlement. But apparently that's not the way it works with this one. So, Mr. CEO, are you saying then to us that any shortfall in funding will be borrowed from the market and there will not be an application to Parliament for a taxpayer bailout?
Yeah, Chair. Yes, at this point, that is not part of our plan to ask for a bailout. We don't think that a bailout is necessary, at least at this stage. We think that if we start using every rand that we receive properly, as we say, in reducing the legal cost, for instance, if you can, over the next 3 years, reduce the legal cost by 7.5 billion, that 7.5 billion would go into settling of claims. So ours is to say, once you start to see those efficiencies work, those efficiencies should at least be able to pay for that. And that's why I'm saying, once you look at that from the asset liability profile and start to pay in installments rather than actually paying people lump sums, you should have enough money to be able to cater for those payments as and when they fall due. So that is our approach to the matter. And we are not at this stage having any plans to come to the legislature or government or the National Treasury for a bailout person. Thanks, Chair.
Mr. CEO, have you approached the market and seen whether there's any appetite in the market to lend you money? And what kind of rates are they talking about?
No, Chair, we are doing a market testing exercise at this point that we are working towards, and our treasury guys are working on that. We won't predetermine where the market is, but we think that it will be much lesser than the amount we are paying now. The simple thing is that we now owe, at least now, we owe 14 billion worth of claims that have been finalized, but not yet paid. And as per the court orders of those claims, most of them at least have got 9% sitting on them as an interest that we are already paying. And we are owing different people. So we are saying we're just going to consolidate that debt and go to the market and ask for that money. So that's a process that would be. So in the market testing exercise would happen. And from that perspective, then we'll place the debt in the market at the right time.
Mr. Chairman, I'm going to call it a day there. I'm afraid I don't have a great deal of confidence in the future, and I hope I'm proven wrong, Mr. CEO. I hope that the next time you appear before us, that the picture is very different, but I'm afraid my confidence levels are pretty low. Thank you, Mr. Chairman.
We'll certainly prove you wrong. Thanks, Chair.
Right, Honorable Somya, over to you.
Well, thank you very much, Chairperson and the Minister and his delegation. One question which has been very pertinent on my side has been process driven, which then something that leads to exorbitant payovers, which are a causal factor for the drainage in as far as the fiscal capability of RAF. I think the CEO is trying to capture that by emphasizing the fact of the reduction of the legal costs. What I would have then, as that assertion has been sound to me, whether they have gone through the entire process, which results into them having at hand what they would call a claim, and therefore a register where that claim arises out of, whether through the legal means or through individuals having processed such, because what does exist is the fact that at times there would be touting for such to happen, whether in hospitals, where there would be some form of collusion between the hospital staff and some legal staff sent to those individuals affected, and therefore the escape route in between the direct application lodgement for such accident claims by individuals affected or legal firms becomes a bit in a clear way. What is it that then the CEO and the institution seek to do to somewhat avert that situation, which for me is very key, is very critical for that reduction of the legal costs. And lastly, I'm asking that question from the strength that the new strategy seems to be sound to the effect that the actual competency of the institution seem to be a bit heightened to withstand the current challenges. The only thing is that how then are you going to ensure that the deficit, which is registered against your performance in the year under review, would in the ensuing years be somewhat be targeted for your actual increased performance. And lastly, this has everything to say that through that acknowledgement, we should not lose sight of the fact that the beneficiaries, the people affected, some of them don't even have that capacity to lodge such claims, and therefore the legal fraternity's involvement in this instance is somewhat very tough to mitigate, and therefore your own institution would have to heighten what I have seen recently, rough stuff being sent all over, right through the country, in various centers, to collect some information, to advise individuals affected, to assist them from time to time to make such applications. Thank you very much, Chair.
Thanks, Chair. The difficulty here is the way in which we get information as well. You would see I have raised the issue about the RAF 3 form. The RAF 3 form is actually an accident report, not what we call the insured. So RAF basically works as an indemnity fund for me as a driver. Instead of me being sued for the accident that happens through my negligence or wrongful conduct on the road, then someone sues the road accident fund. Now, the difficulty with the current state is that in that event, already the relationship is not of a good relationship between a claimant and RAF, because the person is actually suing RAF for whatever happened to as a consequence of this driver. So the driver must actually give us information within 14 days to say, my car or the owner, my car or the car was driving was involved in an accident and these people were injured. For some reason, it was not emphasized. So we don't actually get, if you go around RAF, you are not getting those RAF reforms, because it was supposed to help us to know who got injured, where was this person injured, what is the nature of the injury in terms of this RAF reform. We are actually trying to go on a public education campaign to make sure that more of the drivers or the owners know that there is the responsibility amongst themselves, like in any insurer that you have out there, that within 14 days you must have reported that such an accident has happened and a person has died, also a person is injured. So that helps us with that aspect of the work. Now the question is, there is also a public education campaign that must go on the issue of what are you entitled to. So what are those benefits? There are injury benefits, that there's benefits, and that's why we are saying we want to make sure that we are simplifying those benefits through what later on it will be defined benefits. So you know that if I'm injured, my leg is amputated, this is how much I'm going to get, likely from the RAF, and those things must happen and ensue in that way. The difficulty, Honorable Member, on the issue around direct claims is that in the way that we used to work, which is much more driven by litigation, is that RAF never really moved. We never really moved to make sure we settle claims within 120 days. We actually waited for summons to come before we then respond. That's why we had what we call a panel of attorneys. So once a summon comes, we just give it to the panel of attorney to put in a defense. We are defending something that ordinarily could have settled, but this was just kicking for touch so that there is a trial date. Just before the trial date, then we settle the claim. That's what we are changing. We are now saying give us enough information. Once the information is there, we should be able to give you a claim within 120 days, and you should not have to be able to issue summons, because an ordinary man in the street, he comes, he does a direct claim, RAF does not respond, 120 days passes, that person can issue summons and has got to now go to a lawyer in any event. So that's the difficulty that we have, and in the way that the scheme sits, and this is why certain changes are necessary for us to drive this new model. The competencies and capabilities that we have at RAF are also a difficulty. One, we have got lawyers that must assess someone's injury based on medical reports, which medical reports are written by medical experts. Lawyers are not doctors, so they don't know much about those. But of course, from a point of view of them having worked in the industry for some time, they are able to at least make determinations. But those determinations can never be as competent as where you were sitting and you go for, for instance, disability with an old mutual, who will use a doctor to do the actual work. So we are now saying we are bringing the medical fraternity quite close to the people that make. So our assessments are going to be done by people that are more competent to deal with that. So there will be a multi-team approach to actually settling claims within these 120 days. Now, the issue around the deficit, as I said, it's an issue that is a historical matter that we need to deal with. The issue is whether when you report a liability, you take something that might never come and you call it a liability that you have. And this is where the difficulty of accounting like an insurer creates issues for us, which is something that needs an accounting solution to this issue, which we are working on as well. But the issue around the money that we have and the money that we pay to the claimant and the money that we don't have is this. Where I've said, when we start to get our efficiencies right in time, reducing the amount of administrative costs to the 10% that we are targeting over a 5-year period, we should have that 30% that we are now paying, which is now, it's 40% now. When we reduce it to 10, that 30% must go to deal with the issue of claims. That will help us reduce that. But Chair, I must emphasize, the more road accidents happen on South African roads, the more claims are going to come RAF's way. And the issue is that also needs its own issue where we need to focus on to try and make sure that we reduce that so that we reduce the number of claims that come into the RAF system, as it were. Because if we then take the number of accidents that happen, it means the fuel levy, if it has got to grow by the same amount to match this, is going to be unsustainable going forward. So that the sustainability will be brought by that, but also the sustainability will also be brought by, as I said, the asset profile and liability profile matching, where we are going to be paying people and having various interventions. Currently, if you are injured, you are 40, you are going to retire at 65, we give you 25 years worth of the money today. Issue is, in 5 years' time, you might start to work. Something might have happened, and we would have paid you already. So the issue is, we also need to make sure that over time there are interventions in that regard. We don't want to lose sight of these beneficiaries because it is a moral obligation of the state to take care of the claimant and make sure that the claimant gets the best out of all this amount. We must make sure that we emphasize that the claimant must get more of this rent that we collect from the fuel levy each and every day. So our emphasis is to make sure that we are claimant-centric. We make sure that we take care of this claimant. And for instance, we were asking ourselves, when a child gets injured, this child is 6 years. If it takes 7 years on average, because usually these lawyers, when they are given this claim, they claim in 3 years' time. It's 3 years plus 4 years, that draft takes about 7 years. If a child is 6, by the time we settle this claim, the child will be about 13. What happens to the child in the meantime? So those are things that fundamentally we need to immerse ourselves in to try to deliver a defined benefit scheme that will assist the claimant and take into consideration some of those issues. Because if you don't have someone to take care of those minors, then there is a problem. And RAF must have stepped in at the time because that person loses a father when the person is 6 and then only gets help when the person is 13. That for us does not work. And that's why we are now changing the system to make it more simple and more carry towards the claimant, as it were. Thanks, Chair.
All right, Babu Somyo, are you done?
I'm done, Chair. Thank you very much, CEO.
Okay. Right. Minister, I know that there were issues that had been asked that were asked to you insofar as legislative reforms and so on was concerned. So I will ask that you respond to that. But I think 2 key observations which are very important that come out of this hearing and this interaction is that one, a clean audit is indicative of good financial management, amongst others, and that things are in order and that documents were found and so on and so forth, which is good. The fact that those issues are very much resolved, it's good. But it does not translate into, for lack of a better phrase, to borrow the South African colloquial language, translate to service delivery. And so there may be a need, colleagues, that we find it within our time to drill into the outcomes and the impact of entities and departments generally that have got clean audits. And as you can hear, the challenges with RAF are quite huge, from the issues of liabilities. And of course, there are problems that are not of their own making. Generally, people must drive safely and within the dictates of the law and the road regulations. And of course, the impact of not doing that is that the moral obligation to take care of the citizenry then arises, has already been said. But generally, it's quite clear that a clean audit is not the alpha and omega of impact. Without calling into doubt the good work that has been done to arrive at a clean audit as probably the biggest step towards good governance and the elements of transparency and accountability which we expect. But the question of outcome and impact insofar as achieving one's mandate and meeting your APP and your targets and so on is another aspect which we have to look at. The other issue, Minister, which I'd like to raise so that maybe can be a key consideration of the entity and probably government across the spectrum continues to be the silo mentality of government departments and entities, in that the internal bureaucracies are sort of islands on their own without really the necessary linkages. I made the point before, just as an observation, that if I'm a social grant recipient as a child, and I get to matric, and then I pass and I'm going to an institution of higher learning, I almost have to re-register myself with the very same state, say machinery, for NSFAS, which in one way or the other can be classified as a social grant in itself. So the lack of integration is a problem. And so here I'm thinking all the documents that may be required by one to move from this department, that department, in order for a claim to be complete, does really mean that the so-called talk of the fourth industrial revolution, the digitization and technologification of the state, for lack of a better word, and if I create one, so be it, that's fine. But they really should be ways and means which we build up innovative technological capabilities of the state in order for there to be a seamless movement of information between all the government and entities and state entities really to be able to be one state. And so I hope, Minister, that can be a discussion that can be elevated to the necessary government departments and cluster, and then we see how we assist that integration. But it may help if I register, if I've been involved in a car accident and it's been filed with the SAPS and hospital report, and in the event of death, your BI 1663s and so on and so forth, should really be able to enter one portal of one South African citizen to say that these are my details and these are my realities and so on and so forth, tax matters and so. But people are expected to go to too many offices, and that in itself may prolong claims, delay claims, and then cause further problems. And I think the issue that the CEO raises about if we pay you now for the next 25 years and something happens in 5 years' time, so on and so forth. And so the tracking system of government must go to that extent to say, how do we ensure that the movement and flow of information, in order for there to be effectiveness in the management of state funds, is built up. So, Minister, I'm going to hand over to you, and because I do not have an indication of any other hands, and then we will get the concluding remarks from you and responses to the issues that may have been flagged for your attention. Then the one I picked up, of course, was around the legislative reforms which must take place. Minister Mbalula, over to you.
Thank you, Chair. Thank you, honorable members, for the opportunity. Obfuscation means the action of making something obscure or unclear or unintelligible. Unintelligible, meaning when you're confronted with sharp questions, you resort to obfuscation. So I think this is not what we have witnessed here in terms of what the CEO was doing and giving an account, which I think to the best of his ability and based on work has demonstrated that there is work that is being done and respond with the necessary detail as it was required. So I don't want to get into that discussion, because I think we are very clear that moving forward, we will move with speed with the implementation of the new operating model, which will not only shorten the turnaround time for claims, but will ensure all victims are treated equitably. Progress has been made in curtailing legal costs, which undermine the ability of RAF to pay more claims than it is currently able. The reality is that victims of road crashes should not rely on lawyers to access RAF benefits. This is an anomaly we seek to correct and give everyone equitable access to claim benefits they are entitled to. There is a myriad of challenges facing RAF. This inter alia include insufficient funds from the levy to meet all the claims, unethical behavior by some lawyers, clinicians, RAF employees, actuaries, as it has been stated, by the High Court on the Tibrolio. To the appointment to the CEO of the board, and we are in a process of cleaning house. And a whole lot of things the CEO spoke to. We ourselves have given a strategic direction in terms of what needs to happen. Top on our list was the reduction of the liability, which we are handling that matter with regard to the new operating model, which is going to see a whole lot of changes that you'll see in the next accounting about administrative costs being curtailed and all of that. And as a minister, I'm quite very happy with the board and the CEO. It is for the first time that we have a board that is hands-on, and we have a CEO and the management that is changing things in a very short space of time. I know Collins have gone through a lot of challenges, and it is to be expected. And when I decided, among others, when we're discussing, particularly at the level of the executive, about the caliber of person we need there, among the names that came through, I don't regret the fact that we came to this conclusion. And at some point to support the board's appointment. So I have flagged the matter of the nexus between the number of crashes on our roads and the liability. It is a matter we are dealing with other campaigns. With regard to the RAPS bill, it is a matter that is before the National Assembly, particularly the Portfolio Committee. And I hope it moves with speed because there was back and forth in relation to that. But we seem to be resolved to going forward. Our emphasis really is to ensure that we deal with the matters in the way we deal with, and we've given a clear directive in relation to that. The strat plan and the APP commit to firm timelines in implementing the critical elements of the new operating model. The implementation of the 120-day strategy is a key element of the 2021-2022 APP, and is in the process of being implemented. The suspension of the service of REITs specifically speaks to this matter. We are trying, Chair, as I conclude, to clean up a mess that have been created over and more than 20 years. Like the CEO have said, since from 1981 was RAF bankrupt. We are cleaning that once and for all going forward. So tangible interventions, very hard hitting, no much support, fight back from those we expect to fight back, but nonetheless, we are winning. And I'm confident of that. And it will be reflected in the next report you will get, which was not the main focus of today. At the center of this dealing with the strategy issues, it is the RAPS bill itself. Thank you very much, Chairperson, and thank you for the opportunity.
All right, thank you very much, Minister. Colleagues, are there any other matters that you would like to raise? Going once, going twice, going thrice? Okay. Yeah, Minister, you indicate, as the CEO has, that these problems have beset the RAF since 1981. That was 6 years before I was born. So if that feels long for me, can you imagine how it feels for, well, the rest of my colleagues? So we hope that the agency upon which this matter is, it will ensure that we deal with it now, and that we don't have these repeat issues as if there are no institutions and that there's no leadership. we can't be speaking about the same thing year in and year out. And so I think there's a very strong basis to build upon, having turned the corner onto a trajectory of clean audits. So let's maintain that and not have a regression. That's important. And then deal with the systemic and governance issues which prevail. And then, of course, the portfolio committee is handling the bill. We will get direction from that. I know that there's been requests for issues to be responded to. We generally give 7 days, so today is Wednesday. So if we can get all those written issues, we'll follow up when necessary, and then get those by next week, Wednesday, close of business. And then, colleagues, what we will do is that once the annual report and the audit outcomes reach us at the end of September, October, we will prioritize the RAF matters so that we get a sense of progress and gauge progress then. And then the audit action plan, I would imagine, will have to flow from that, in tandem, of course, with the other issues which the entity is setting to motion, the 5-year plan and so on and so forth, and we'll get that. So colleagues, if you've got any other questions that you want to raise, you can send them through to myself and the Secretariat, and we'll transmit them through to the department and the entity as a matter of priority so that we can receive those responses by next week, Wednesday, close of business. So I'd like to once again thank the Minister and the Deputy Minister, DG, Chairperson of the board and the board, and the CEO and the officials of the department and the entity for your appearance this morning, so that we can tie down on all the loose ends on these issues, and then keep Parliament on an informed basis in terms of where things are. Colleagues, I'd like to thank you very much, and to our Secretariat and team, thank you very much as well for this meeting this morning. So I think there are no other issues. Suffice it to say that the problems are there and they have to be fixed, and a trajectory of good governance has been set, and it's clear that it's possible to turn things around. Let's keep on that direction and deal now with the difficult issues of cash flow, financial management, and so on. So, Minister, thank you very much to you and the team. On that note, colleagues, the meeting stands adjourned.
Don't leave the chair. Thank you very much.
Oh, thank you. But Mam Tolash is not here. I was really wondering who would close us off on that note. So thank you very much, Minister.
Okay. All right.
Thank you.
Recording stopped.